Good morning, everyone. As Ashley said, my name's Mark Mellick. I'm with Active Law. We're a full-service body corporate firm, so we can assist any body corporates with any of their legal requirements. I'd like to take the opportunity to thank Capital for inviting Andrew and I today. It's always good to get out and about and conduct these types of seminars. I'd also like to say how good it is to be back at Redcliffe. I come down here sort of once a year these days, but in the past I had an auntie that lived in Redcliffe, so I was down here most weekends as a child, and so I've got a certain affinity for Redcliffe, and I drove past Dunbar Street on the way here and it brought back some very fond memories. In terms of what I'm talking about, as Ashley said, it's trends in bylaws, but before I talk about the types of bylaws that are causing people angst out there in body corporate land, we're just going to have a little chat about how bylaws come about and how we change them. So this morning I did a little bit of searching, a little bit of a history lesson on how long we've had this concept of bylaws, and to my somewhat surprise, the term bylaw has been around essentially since the late 13th century, I found. So it's Old Norse or Old Danish, and essentially it's a local law pertaining to local residents, hence a standing rule of a corporation or association for regulation of its organisation and conduct. And that term regulation has become increasingly important when considering and interpreting bylaws, and it's something that I'll touch on shortly. Yep. So, what are bylaws? Well, essentially they're rules that govern harmonious living in a community title scheme. Now, whenever I talk about bylaws, I generally start with saying, if people just acted and behaved in a courteous manner, we actually wouldn't need bylaws. You would never, ever, ever have to have recourse to bylaws if people just treated each other courteously, because when you read your bylaws, you can essentially distill those down to people behaving in a manner that we would like them to behave in. That said, the reason we have bylaws and the reason they're in a document and the reason they're registered in the Land Titles Office is because they create a contract between the lot owners. And but for that contract, you would not be able to enforce your bylaws. So that's why they're written down. Now, body corporates are a creature of statute, which means bylaws are a creature of statute. So whatever the Act says bylaws can do is all that they can do. And the Act says that they may only provide for the administration, management and control of common property and body corporate assets. The regulation of, there's that word again, regulation, so not prohibition, and we'll come to that again shortly. So the regulation of, including conditions applying to the use and enjoyment of lots, common property and body corporate assets. What is really, really important is that a bylaw is effective from the date the new CMS is recorded in the Land Titles Office. So if you amend your bylaws, and that new CMS incorporating that new bylaw might take, say, 3 months to get recorded for whatever reason, you can't enforce that new bylaw until such time as it is physically actually recorded in the Land Titles Office. And that's important to remember when it comes to body corporate committees or body corporates who might be putting in a bylaw to restrict some type of specific behaviour by a particular resident. And as soon as that motion is passed, whereby the owners resolve to adopt that new bylaw, the committee go, okay, owners agree to that new bylaw, we want to issue a contravention notice. You can't do that. You can only issue that contravention notice for that new bylaw when that new bylaw is recorded. So how are new bylaws recorded? Generally, a special resolution of the owners in general meeting, unless we're messing around with exclusive use bylaws. So if we're granting exclusive use of common property, if we're taking exclusive use away, in my view, if we're changing the conditions of a grant of exclusive use of common property, then you're going to need a resolution without dissent, which means no one can vote against the bylaw. What bylaws cannot do? Again, bylaws, body corporates, they're a creature of statute, so the Act sets out what bylaws cannot do. And they can't be inconsistent with the Act or the regulation module. So I've given the example there for those of you that have resident unit managers. A bylaw, for example, cannot give exclusive use to a resident unit manager of a storage area where that storage area is used to facilitate the carrying out of the caretaking duties. Now, why is that inconsistent with the Act? It's because the Act says a caretaker can only occupy common property to perform its duties by way of a common property occupation authority. So if the caretaker wanted exclusive use of a storage area and that storage area was to facilitate caretaking duties, then the chairperson would need to rule that bylaw, that motion out of order, should a motion be included in an agenda. That's not to say, for example, a caretaker can't get exclusive use of a car parking space, because that car parking space may not be used for the fulfilment of its duties. If a lot may lawfully be used for residential purposes, the bylaw cannot restrict the type of residential use. And that is why, and the only reason why in Queensland, you at the moment cannot restrict Airbnb and other types of short-term letting platforms. And we are talking about angst, bylaws that cause angst. This is one of them at the moment, but for those of you that are arguing or wondering why Airbnb can be banned in other jurisdictions, it's because their legislation doesn't contain that legislative provision which says if it can be used for residential purposes, the bylaws cannot restrict the type of residential use. Some of you are no doubt saying, well, if you're using it for Airbnb, that's a commercial use, it's not a residential use. That's not how this legislative provision has been interpreted. The Airbnb or stays or whatever it is, they're using it for a residential use because they're staying there. So therefore, under the current state of the law, it is not able to be prohibited. A bylaw must not discriminate between types of occupiers. So sometimes I see committees say, well, we only want the owners to use the pool, not the occupiers, and we want that in the bylaws. You can't do that because that's discriminating between types of occupiers. A bylaw or other, an exclusive use bylaw, must not impose a monetary liability. You've probably seen bylaws which say if you're moving furniture in and out of the building, you need to give $1,000 to the caretaker, and we use that as a security bond for any damage that you might do to the common property. If that bylaw was challenged, then that would be ruled invalid because it imposes a monetary liability. It's this legislative provision, that's the reason why you can't have bylaws that impose fines. So, for example, I have been saying for a number of years through various organisations that I'm involved with that the best way for people to follow the bylaws is for it to hurt their hip pocket if they don't follow the bylaws. And Andrew's certainly going to be talking shortly about how fines can be imposed through the Magistrates Court. But if the body corporate was able to impose a fine, and that fine went, for example, into the sinking fund, then my view is I think you'd have a lot more occupiers complying with the bylaws. Because as it presently stands, they may know that, okay, the body corporate's got to go through the contravention notice regime, and then there's steps after that if you don't comply with various orders. So it's a long road to hoe for the body corporate. But if the body corporate could impose a fine, I think that would be a bigger stick for people to comply with the bylaws. Some further legislative provisions are that a bylaw must not be oppressive or unreasonable, having regard to the interest of all owners and occupiers and the use of common property. And it's that word unreasonable that owners really and occupiers really latch onto when they're challenging a bylaw. There's also a legislative provision, section 94, which is a coverall provision, which says that a body corporate must act reasonably in any decision it makes. So if an owner or an occupier wants to challenge a bylaw as being valid, the first thing they're likely to do is say, well, that bylaw is unreasonable. And they'll run that argument. Now, over the years, I've seen or met some committees who have wanted some what shall we say, doozy bylaws put into their scheme, and one came across my desk recently, which was the committee wanted a bylaw which said that if an occupier brings a visitor to the scheme, the visitor must not enter the scheme until such time as the committee approves. Now, I can understand the committee. I mean, they've got the interest of the scheme centre of their hearts, I guess. But two issues with that is it's patently unreasonable. The second issue is how do you police it? And I gave the example to this committee of if there's an occupier who goes out on a Friday night, meets a young man or woman, brings the young man or woman back to the scheme, and then says, hold on, it's 2 o'clock in the morning, can you just wait at the gates? I've got to ring the 7 committee members and I've got to get a majority resolution for you to enter the scheme. That's not going to happen. The other one that they wanted was if you have more than 5 people in your lot, then you've got to get committee approval. Again, how is it possibly going to be policed? So, as committee members, if you want to change your bylaws and you're giving thought to some new bylaws, just bear in mind, not only can they not be unreasonable, and I think objectively speaking, anyone in the room would say the 2 examples I've just given are patently unreasonable, but also think about how they're going to be policed. Because remember, resident unit managers, caretakers, their role is not to police bylaws. Their role is just to monitor the observance of them and report breaches back to the body corporate. So when you're wanting to consider your bylaws, think about who's going to make sure that on the ground that they're being adhered to. I won't talk much about ban the banner. That's there because of the Sustainable Planning Act. That came in a few years ago. It really is a topic of itself. But essentially a bylaw must not offend the sustainable housing provisions of the Building Act. And the most common example given is you can't restrict the use of solar hot water systems merely because to preserve the amenity of the scheme. Andrew's given advice over the years about that, and if you've got any questions about that, perhaps you can have a chat to Andrew at the conclusion. Contentious bylaws, trends in bylaws. It may come of some comfort for you to know that the same issues that we have in Queensland with bylaws are the same issues they have in Vancouver. They're the same issues they have in New York. I recently went to a conference of community titles lawyers. As you can imagine, that was an absolute blast. And there was people from New York, there was people from Vancouver, and same issues: towing, pets, parties, smoking. So we're not alone. We're not dealing with this in isolation to anywhere else in the world. Towing. Towing still comes up with monotonous regularity across my desk. I will be the first to admit towing is a massive problem in body corporate world, but until such time, in my view, as the legislation has changed to enable recalcitrant occupiers to be fined or towed, then I believe the problem will continue to exist. Now, towing occupiers is an issue because what the adjudicators have said is you need to go through the bylaw contravention regime. So if you have an occupier that is illegally parked in a visitor car space, then the proper way to deal with that under the current state of the law is to issue a bylaw contravention notice. And you're all thinking right now, well, that gets the body corporate absolutely nowhere, and I 100% agree with you. The other thing is, remember, I said before, Section 94, a body corporate must act reasonably. If you've got an occupier parked in a visitor car space for, say, 2 hours, the general consensus appears to be it would be unreasonable to try and enforce a breach of bylaw for someone parked in a visitor car space for a limited period of time. Visitors. If there's a bona fide visitor that's illegally parked on common property, you can tow, provided that you've got proper signage to tell them that if they breach certain conditions, they're going to be towed. For those of you that go into large shopping centres, you'll notice that before you drive in, there's generally a boom gate, and there'll be a list of, there'll be a board which has a whole lot of conditions that none of us ever read. Those conditions are simply there to create a contract between the shopping centre owner and the car driver to say that if you proceed past the boom gate, then you agree to park in my shopping centre under these conditions. Same thing with a body corporate. If you've got appropriate signage which says if you breach the conditions for visitor parking, then we can tow you. The difficulty, of course, is establishing who a bona fide visitor is compared to an occupier. Many committees say to me, you know what, I know he's an occupier, but he parks there all the time and we're going to tow him. And, you know, at worst, we might have to pay back the $400 impounding fee that he or she has to pay to recover his vehicle. It's not so much the impounding fee, the paying back of the impounding fee that worries me. What worries me more is if there's damage caused to the vehicle by the towing company. I can see the body corporate in certain circumstances perhaps being liable for that damage as well, because generally the arrangements between a towing company and the body corporate in the towing contract will contain an indemnity by the body corporate in favour of the towing company, essentially the towing company saying, hey, we're just towing this car. If anything happens to it, it's on you, body corporate. So for those of you that are in body corporates that do have arrangements with towing companies, my recommendation would certainly be to get that towing contract checked to make sure that it's reasonably fair to both the towing company and to the body corporate, and to make sure that the body corporate's not giving away indemnities when it otherwise should not be. When I gave this talk in Brisbane, a gentleman asked about wheel clamping. Can you wheel clamp? The answer to that is no. Wheel clamping is illegal in Queensland. Pets. People still having a problem with pets?
Oh yeah.
That's generally the answer I get. Anyone in the room still think that a body corporate can ban pets outright?
No.
Excellent. The message just got through. The reason you can't ban pets outright is because what I said originally, bylaws can regulate behaviour, they can't outright prohibit behaviour. And that's why the current state of the law is you cannot ban pets. I am of the view, for what it's worth, that I think the adjudicator probably need not have delved into this area, because if a scheme had a no pet bylaw, people buying into that scheme know that it's a no pet scheme, and that's what the owners want. The owners always have the opportunity to change their bylaws. So if over the years the demographic of that scheme changed from the owners not wanting pets to the owners wanting pets, then that could have gone to the owners in general meeting. They'd pass a special resolution, and you can change your scheme from no pets to pets. That ability was always there. The difficulty for the adjudicator is the term regulate in that provision I mentioned first up. So as it currently stands in Queensland, you can't outright ban pets. That's not to say that you can't impose reasonable conditions on the keeping of pets. And our, for want of a better word, model bylaw for pets essentially has about, I think, 10 or 11 conditions which a committee may impose. It's critical that if you've got a bylaw which says, for example, the committee, you can only keep a pet with the approval of the committee, and the committee can impose conditions. It's critical that when considering the approval, that the committee does in fact impose those reasonable conditions. Okay, so if you're on a committee and someone wants a pet application, wants to keep a pet, and you've got to give consideration to it, make sure you go the extra step of saying, okay, we approve the pet subject to these conditions. And it's certainly been held by adjudicators that if the owner of the animal breaches reasonable conditions, then that pet may be removed from the scheme. So you do have some ability to get rid of a pet. Of course, you've also got, for a raft of bylaws, not just pets, you'll also have a general nuisance bylaw, and you'll also have the nuisance provision under section 167. The other thing I want to say, now that we've spoken about nuisance, just bear in mind that because you live in a community title scheme, you don't lose the rights that normal owners have. So if you have a dog which barks all day, you can still report that to your local authority in the same manner that if my next door neighbour has a barking dog, I can report that to the local authority. If someone's having parties week after week after week and there's loud noise at 2 a.m. in the morning, you can report that to the local authority in the same way that I can report my neighbour for that type of behaviour. Just on pets, we're still seeing committees wanting arbitrary weight limits. That's been ruled invalid for quite some time now. The simple reason is, A, how are you going to police it? You know, if you have a bylaw which says a dog can't be over 10 kilos and it, for 1 week it eats a lot and it gets to 11 kilos, who's going to weigh it and who's going to chop its leg off so that it comes back to 10 kilos? So again, think about how these bylaws are going to be policed. But the reasoning behind arbitrary weight limits is, and not allowing them, is one, it's arbitrary, and two, you might have a 15 kilo Labrador that sits in the corner all day and is as quiet as a mouse, and a 2 kilo terrier that does nothing but yap and bark all day. Not that long ago, I gave some talks with the Commissioner in regional Queensland, and someone in the audience said, well, what about dangerous dogs? And I formed the view that I think it was reasonable that if a declared dangerous dog breed was put up for approval, then it would be reasonable for the body corporate to say no. The Commissioner didn't share my view, and the Commissioner's view was simply based on the fact that each case needs to be looked at by its merits. So just because a breed is declared dangerous doesn't mean that the dog in question is dangerous. So the moral of that story is you've got to look at each individual case on its merits and impose reasonable conditions to the keeping of the pet. There may be cases where it is entirely reasonable to say no. I haven't come across any yet, but I don't know, let's say for example someone wants to keep a crocodile. That wouldn't be entirely reasonable. I have heard of people keeping venomous snakes. I haven't had the course to look at whether there's any decisions as to whether it's reasonable or not reasonable to say no to that. I have a phobia about snakes, so I would probably sell my unit and move out. That said, I did face my phobia at the Kingaroy show on the last weekend and went to a venomous snake show. I was about 20 rows back though from everyone else. Smoking. That is increasingly becoming an issue in bodies corporate, and I suspect because less people are smoking today than they were 10, 15, 20 years ago. You can't restrict smoking in lots. Whether that changes as a result of legislative change remains to be seen. In my view, you can restrict smoking on common property. You can certainly restrict smoking in enclosed spaces on common property. I think it's reasonable to restrict smoking, for example, around the swimming pool. We have what's called a smoke drift bylaw, which says that you've got to restrict smoke drift to other balconies, lots, if that is likely to cause a nuisance to another owner. That's at the moment the best that you can do through the bylaws. But of course, for occupiers as opposed to owners, an owner who rents out their unit to an occupier can of course restrict smoking, they can restrict pets through their residential tenancy agreement. So if you get all the owners, so if it's entirely 100% rental and you get all the owners on board to say, okay, in our tenancy agreement we're going to restrict smoking, then you will have a smoke-free building. Security bonds we've spoken about, they're illegal. That said, people still would like to see them, and again, because you can't impose a monetary liability, that's why you can't impose fines on recalcitrant owners. Airbnb, at the moment, the only way that's going to be dealt with under the veil of body corporate law is through legislative change. I shouldn't keep saying Airbnb, should I? I should say any short-term letting platform, because there's more out there than Airbnb. So for those of you that are anti-Airbnb, the best thing you can do at the moment is lobby your local member for legislative change. I'm a bit torn, to be honest, with short-term letting in body corporates. I can understand why particularly owner-occupiers, are anti-Airbnb, because it's certainly, nuisance might be too strong a word, but there's the coming and going. There's extra use of the common property, and unless people agree by resolution without dissent to change the contribution schedule lot entitlement of the owner that's letting out their lots on short-term letting platforms, then that's not going to get fixed up. But the reason I'm sort of divided is because if you own a unit, then you should be able to use your unit as the planning scheme allows you to. And to put a restriction that you can't let someone put their unit on sites like Airbnb may become a fundamental impinging on proprietary rights. You know, you're essentially saying to someone who is not, so the body corporate's not the government, but you're essentially saying to someone, you can't use your lot for a lawful use. So that's my issue with putting aside, obviously, you can't do it under the legislation anyway, that fundamental legal proposition of being able to use your property how you wish, provided it doesn't conflict with local authority planning laws, is fundamental to property ownership. So I just want to, I raise that simply as a discussion point for those people that are vehemently against Airbnb. Just perhaps have that in the back of your mind when you're having debates about the use of lots under those short-term letting platforms. Airbnb stays, those short-term letting platforms, don't forget, of course, if they are a breach of the planning scheme, then you can report that to the local authority, and the local authority will take up the fight for the body corporate. Some things that I don't have up there but that have been coming across my desk in recent times is, whilst I do have smoking up there, recently I've been asked to include vaping to make sure that that's captured in any smoking bylaws, smoking, vaping. I acted for a scheme on the Gold Coast, a massive scheme. It had a lot of Middle Eastern tourists come over and stay at the scheme. It seemed to be the scheme for Middle Eastern tourists to stay at. So that body corporate specifically asked me to incorporate into a smoking bylaw those, I think they call them hashish pipes, you know, the big pipes, and they, yeah. So that got put in. Drones. Recently been asked to put bylaws in regulating the use of drones. Internal flooring, that's becoming more and more of an issue. So if you change internal flooring, a lot of body corporates want to make sure that the acoustic level of any new flooring doesn't cause unreasonable noise transference. And that's all fine, provided that whatever acoustic noise level the body corporate adopts is reasonable. And you're probably aware there's certain ways that people measure acoustic noise, but let's say you've got a 3-star building, so general, average, run-of-the-mill building, 3 stars, you might have an acoustic level which is somewhat higher, or I think the lower the number, the quieter. So you might have an acoustic level which is higher than, say, the acoustic level in a 6-star building. So whatever acoustic level you adopt, just make sure that it's reasonable. Okay, and you might need to get an acoustic engineer's report as to what is reasonable for your particular body corporate. Communications bylaws is something that we've been asked to put into bylaws recently. Anyone familiar with the Tank Tower decision? Tank Tower? No? So Tank Tower is a scheme in Brisbane. There was an owner in Tank Tower that sent voluminous amounts of material on a daily basis to the committee and to the body corporate manager. It essentially, for all intents and purposes, was out-and-out harassment. So someone went to the adjudicator's office, and the adjudicator made an order restricting the method of communication and the period of communication from this owner. So based on that decision, we now put in essentially what we call a communications bylaw, which says that if you're going to communicate with another owner, an occupier, the body corporate manager or the committee, then you've got to do so in this manner, which is a bit more courteous than just flying off 100 emails a night. The point, though, that I need to make is if someone's flying off 100 emails a night, and irrespective of whether you've got a Tank Tower type bylaw, unfortunately the committee is going to have to make sure that out of those 100 emails, 98 are rubbish, and there's 2 that don't need actual attention. So if out of those 100 emails, 2 relate to a defect in the common property, and that defect is dangerous or needs immediate or quick attention, then the committee, of course, needs to action that particular issue. House rules, I don't see the point of them because it's only bylaws that are enforceable. So if you see something which says the committee can make house rules, my view is if the committee has something in particular in a house rule, put it in the bylaw. Have a special bylaw for it because you can't enforce house rules. In closing, I just want to say that bear in mind, irrespective of what your bylaws are, so if you've got a no pet bylaw in your scheme, that's valid until it's ruled invalid by the adjudicator. So if you've got a no pet bylaw and you seek to enforce it, technically you can, because that bylaw for your scheme hasn't been ruled invalid yet. It will be ruled invalid at the adjudicator's office, but the point to make is a bylaw is only invalid until when it is ruled such by the adjudicator. And I think my time is up. Ashley, did you want questions now or at the end of Andrew's?
Just finish the video.
Yep.
Finish.
Excellent.
Questions now?
No, we can take questions, yeah.
Now, so if anyone's got questions, we're taking them now.
No questions. Oh, yes, this lady here.
I didn't say this first. When you talk about Airbnb, what about people who actually rent out their rooms? Is that legal? Assuming it's a 3-bedroom unit and they're renting out a 2-bedroom?
Yeah. So the question was, putting aside Airbnb, if people rent out individual rooms, again, I don't think there's anything you can do about that under the bylaws because that would impinge the restriction on residential use, but it certainly may be something that your local authority would be interested in. I'm certain there's rules, and it depends on the local authority, but I'd be surprised if there's not rules about how many lodges, boarders, etc. you can have before you're in essence operating a commercial enterprise.
I was just going to ask, in your pet conditions,
Mm-hmm.
can you insist on pets that require some sort of council permission, permits, registration?
Yep, so
Can you put those in?
yeah, so our pet conditions, just by way of example, so if a pet needs to be registered with the local authority, then
Snake.
then you've got to give evidence of the registration. We might put in things like if you've got a lift in your scheme, that the animal can only enter the lift if it's empty, or if those persons in the lift give permission. We might put things in like if the animal is on common property, must be on a leash or otherwise appropriately restrained, and can only be on common property for the purposes of exiting and entering the lot. Yeah.
If the bylaws are silent on the requiring registration, and we did it in our original letter of approval, can we change our letters of approval?
No, once you've given the conditions. But if the bylaws are silent,
Yeah.
you've still got, like if it requires registration, then of course you've still got the council requirements. I think a gentleman, yep, thank you.
What's the process of changing bylaws?
Changing bylaws.
And the second part is for a simple change.
Yep.
What's the cost?
Okay. For changing bylaws, the process is you do a motion, which goes to the owners in general meeting, so be that an extraordinary general meeting or an ordinary resolution. So let's use the example of a no pet bylaw. If you've got a no pet bylaw and as a committee you go, well look, that's clearly invalid on the current state of the law, so we're going to change our no pet bylaw to you can have pets with the approval of the committee, and here's a raft of conditions we may impose. That gets drawn into a motion, a general meeting motion submitted by the committee in that example, and it essentially says the owners by special resolution resolve to delete bylaw 3 and replace it with new bylaw 3 in the following terms. If the owners resolve by special resolution to adopt that bylaw, then you've got to go to the next step of getting a new community management statement which inserts that bylaw registered in the Land Titles Office. Now, I think the Land Titles Office registration fee is $91 at the moment. In terms of the cost to prepare that new CMS, that how long is a piece of string? Like, because your CMS might be 10 pages, another schemes might be 50 pages. So let's just, like generally if I'm asked to give a fee estimate to prepare a new CMS, it's roughly around $950 plus GST. One thing you do need to be mindful of is if your current CMS has exclusive use plans attached to it, and a lot of them do, sometimes depending on how much money the government needs at any given time, the Land Titles Office gets quite anal in terms of the quality of the exclusive use plans. So you might get what we call a requisition out of the Land Titles Office saying, thank you for your new CMS, but these exclusive use plans, and we may not have changed those at all, these exclusive use plans don't comply with the registrar's requirements. Can we get some new exclusive use plans, please? That, as I said, depending on the mood of the Land Titles Office at any given time, they get quite antsy, sort of May and June as you're coming up to budget, but just bear that in mind. Yes?
Is there a generally accepted time frame for parking in a visitor car park, and does it need to be in bylaw?
Yeah, no. So provided you're a bona fide visitor, you can park in there. I have seen decisions which, for example, I'm an occupier in a lot and my mum lives overseas and mum hires a car and she parks in the visitor car space for 2 weeks. Mum's a visitor and that's what the car space is for. Okay, just on, so the point is you've got to be a bona fide visitor. And that's sometimes difficult to ascertain. Just on visitor car spaces, say you've got 10 and they're never used, often I'll have a committee say, you know what, we want to give 2 of these visitor car spaces to an owner or an occupier. Just be mindful of your development approval requirements. Sometimes your development approval might say you need 10 visitor car spaces. So if you give 2 out of the 10 away, then you're going to be in breach of your the body corporate will be in breach of its development approval. Yes?
Yeah, talk about solar power and hot water systems, you still would have to apply to the VC committee for approval?
If it's an improvement to common property, yes. But whether...
If it's on the resident, your own residence?
If it's a change to the external appearance of a lot, I would have thought so. And if you've got that bylaw changing the external appearance of a lot, whether it then becomes reasonable for the body corporate to say no, we'll probably go back to that ban the banner type legislation, so it depends on the reasons. Certainly if the body corporate says, no, we don't like it because it's going to change the aesthetics of the scheme, then that's going to offend the Sustainable Planning Act.
The precedent's already there, that's the
Okay.
problem.
Yeah.
I just wish we had to apply.
Yeah.
Thank you.
Yes?
Yeah, good morning. Thank you for your speech, Jim. If we've got an issue with the Airbnb side of things, why as a group under Capital don't we band together to put pressure on government to change the legislation?
Well, I think there is pressure on government to change the legislation. There's a working paper with QUT which addresses a whole lot of things. It addresses towing, smoking, short-term letting. So that's certainly, as I understand it, before the government. When Jared Lige was the Attorney General, he actually he was quite interested in body corporate world, and we were very close to getting a whole lot of amendments, which in my view are needed to the legislation through. But then, of course, that government got voted out. The current government doesn't quite have legislative change in body corporate world at the top of its list. But certainly I think there is, the government is aware that body corporates by and large don't like short-term letting platforms. Owners don't like other owners using their lots for short-term letting platforms, and I think they accept that causes, or potentially causes nuisance, certainly causes more use of common property. So it is on the government's radar, but I think there's quite a few things higher up their list of priorities and changing the body corporate legislation at the moment.
Thank you.
Would it be possible for the body corporate under the bylaws to, you mentioned house rules before and you said you weren't in favour of that. Could your body corporate not impose house rules on short-term? I guess they must comply with this.
Yeah, but the problem is, how do you enforce it? Because if it's a house rule, then that's not enforceable. So only bylaws are enforceable. And so you can't enforce a house rule, so it's essentially meaningless. And you can't have a bylaw which bans Airbnb or the like. So that's the issue at the moment. So it requires, the simplest way to talk about short-term letting platforms is, at the moment, it requires legislative change, but if using your unit for short-term letting offends the local authority planning scheme, then that's a matter for the local authority to take up.
So I'll just flip it. If you're staying in a hotel like here and they had house rules when you checked in, so they're unenforceable?
Yeah, well, I don't know if this hotel's a body corporate, but house rules, in my view, are unenforceable because it's only bylaws that are enforceable. One more?
In regard to pets, if our bylaws already say that you don't need to apply for a dog under 10 kilos, which you just said is illegal, does that mean that if somebody's got a pet that is over 10 kilos, they don't have to actually apply, or how would that work?
The way that would work, so the question was, if the scheme here has a bylaw which says, essentially to flip it around, says if you've got a dog which is over 10 kilos, then you need body corporate approval. If you have a dog under 10 kilos, then you can keep it in your lot without body corporate approval. Is that? Yeah. Yep. So if I was an owner coming into that scheme and I've got a 15 kilo dog, I bring that 15 kilo dog in. The committee says, oh, sorry, that's in breach of our bylaws. I say, well, that's all very well and good, but your bylaw's invalid. The committee should then, I know it sounds self-serving, but before they go down that bylaw contravention notice regime, and Andrew touches on this, the committee would get legal advice, and the advice would be, if you sought to enforce that bylaw, it would be held to be an invalid bylaw, so you're essentially wasting time and money trying to enforce it. Our recommendation is that you go to the owners in general meeting to change your bylaws so that you've got you can keep any pet with approval subject to certain conditions.
And also in that bylaw it says that they can have one dog or one cat, if they want two, they've got to get body corporate approval. So how does that work?
Yeah, again, limiting the number of of pets would be held to be invalid in the bylaw. So essentially what the adjudicator, in my view, does is he's trying to put in place in community title schemes the same rights that owners generally have within reason, that owners generally have if they were living in a freestanding house. Okay?
The last question.
I just want to let you know that my understanding is that council have a regulation of how many pets can be
Yeah, I have.
within apartment
Yeah,
units.
yeah, and I've certainly heard of that. The reason I don't.
It's not
Yeah.
available.
No, the reason I don't touch upon it here is because each council's different.
Yeah.
So I won't purport to be an aficionado on.
Sure.
Yeah, absolutely, and that's what I mean about Airbnb. Certainly, if councils have in place you can only have X number of pets, then yeah, absolutely, that's reported to the local authority. That's not dealt with through the bylaws.
Thanks very much, Mark.
My pleasure. Thank you, everyone.
Smart.